Good evening, everyone. Thank you for coming to Sydney Law School this afternoon for the next event in our series, Let's Talk About Corporations. This is a joint initiative of Sydney Law School and the University of Queensland TCBNE School of Law. And on the registration page, you can find links to recordings from our previous events. Before I introduce our speakers tonight, I would just like to note that we're meeting on the lands of the Gadigal people, who are the traditional custodians of this particular country. Of course, this area has been a place for learning and sharing of ideas for generations and generations. And I'd like to pay our respects to their elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples who might be here with us either in person or on Zoom today. The topic for discussion this evening is AI risks in the financial sector, consequences for companies and directors. And I'm delighted to introduce two of my fabulous colleagues here in Sydney Law School. Firstly, we have Susan Bennett, who is the Principal of Sabenco Legal and Advisory. She's also the Founder and Executive Director of InfoGov ANZ, and she has recently completed her PhD here at Sydney Law School. She's also an alumnus of Sydney Law School through her Masters of Laws. Our second speaker tonight is Dr. Zofia Bednaz, who's also my colleague here at Sydney Law School, where she's a lecturer in commercial law and corporations law. Zofia is also an associate investigator at the ARC Centre of Excellence for Automated Decision Making and Society, which is part of Sydney Law School. And in that particular capacity, she is conducting research into artificial intelligence and financial services, which of course is part of the large topic tonight. Our third speaker for you this evening is the Honourable Justice Michael Lee, who was appointed to the Federal Court of Australia in 2017 and is the Court's National Coordinating Judge in the Commercial and Corporations National Practice Area. Justice Lee is also an additional judge of the ACT Supreme Court and an alumnus of Sydney Law School. If you can join me in welcoming our speakers. Just a quick point of housekeeping before I hand over to Zofia. The speakers are happy to take questions at the end, so we'll have Zofia and then Susan and then Justice Lee. Zofia.
Thank you, Jason, so much for the introduction, and it's such a privilege to be here with you chairing this session and my colleague Susan and his honour Michael Lee. So what we're talking about today is that increasing use of AI tools, and we're focusing on financial firms. And we're asking what it really means for those terms in terms of risks. And why there's no doubt that AI tools bring lots of opportunities, innovation. There are also some inherent risks. Can you bring the microphone closer? Risks that are related to the use. So we know that financial industry has always been data-driven. And so it's no surprise that they quite quickly...
Excuse me, I don't think it's working properly, the hearing. I don't think your projection is working.
It's what?
Should I? Sorry. I don't know how to... Like this? Can you hear me now? Yes? Sorry for that. So I was just introducing the idea that we're using... so the financial firms are using AI more and more, and while it comes with potentially great opportunities, it also comes with risks, and this is what we'll be focusing on today. So recent surveys show that there is this sentiment of uncertainty in Australia in relation to AI use. So businesses would like to see more regulation to address this uncertainty. And it actually goes, so this uncertainty actually goes so far as for the corporate leaders to believe that Australia is AI Wild West, since there is no AI-specific regulation. But actually, we know that this idea of AI Wild West is very far from the truth. We've got legal regulatory framework that does apply to the use of AI technologies. and it needs to be obviously complied with. And this is, I think, in particularly important in the context of financial industry, because on the one hand, it's very heavily regulated, and on the other hand, as I said at the beginning, it's quite the use of AI tools is increasing very rapidly. So we think that good AI and data governance can prepare companies to deal with those risks. Susan, what do you think, what the boards should be thinking about?
Well, I think the issue arises that a lot of these technology systems that are already in use, that use AI, and ones that are coming to market very quickly with great abilities to process and train large language models and do wonderful things. As Zofia said, it comes with a lot of risk. It comes with a lot of responsibility for boards. And one of the practical issues is that organisations, the way that they're traditionally structured, are quite siloed in the way that they operate. And this is a real challenge, both in relation to managing risks, which we'll talk a little bit more about later on, and how that can be mitigated, but also in what flows up to the board. And this was one of the issues that came out of the Banking Royal Commission about what the board is receiving in its board reports. And they receive a lot of information, but is it the right information, identifying the right risks? So we're going to be talking later on about what are some of the practical ways that those risks can be mitigated.
So just quickly, and in terms of general overview, this is some recent data from the UK. So in general terms, we know that AI applications, and that includes machine learning, are becoming ubiquitous in the financial industry. And the uses of those AI tools range from assessing creditworthiness of bank customers to fraud detection systems. And what's actually not included in that diagram yet, it's the very recent rise of the large language models, or LLMs, or generative AI, which can, for example, be used in communication with clients through chatbots. So let us focus on those potential harms that flow from AI systems. So following a recently published report from the Human Technology Institute at the UTS, we can classify those harms or risks in three main categories. So first, we have risks that derive from AI system failures. So that would include poor or biased system performance, but also security failures. So the system may come up with biased outcomes, for example. That could be in credit scoring context, or there may be privacy breaches due to system failures of fragility. Secondly, and that would be the bottom sort of orange row, yellow row on the slide here, because we're looking at it also from the company perspective. So another group of harms that can originate as a result of using those AI tools would be because of the overuse or inappropriate or reckless use of an AI system. And so the good example here would be the issue of excessive use of intrusive tech, such as facial recognition technology at scale. But even more recently, I would think that the attempts to apply generative AI, such as ChatGPT, to a range of tasks that it's not perfectly suited for is also another potential example. And finally, we have sort of external risks that are linked to AI systems. So those are links to AI systems that are used by others in malicious ways, such as AI-powered cyber attacks. And this is also something that firms obviously need to deal with. And as example, we're going to use a couple of recent class action lawsuits from the US that provide a good illustration of some of the harms that I just mentioned. So first, there is the Wells Fargo lawsuit, which is against a bank. And in this lawsuit, the plaintiffs allege that the bank discriminates against black lenders. And they point out that black clients are refused prime rate mortgage loans even when they have an excellent credit score. And the bank actually does admit that it uses models which take into account more than just the credit score when they assess the creditworthiness of a client. They also use other factors, but it's not really clear what these are and what types of models they're using. And the second example is the State Farm insurance lawsuit, which is actually backed by research that was conducted by the New York University School of Law. And they allege that black homeowners were discriminated against, were claiming on their home insurance. So the claims that they filed were subjected to greater suspicion, higher scrutiny than white homeowners' claims, which resulted in black policyholders having to submit extra paperwork to justify their claims, needing to interact more with the insurer to have their claim approved and paid out. And they were actually significantly less likely to have their claim processed in less than a month. And it is alleged that this is due to State Farm automating their claim processing systems. And instead of using a human judgment, they rely on data analytics and machine learning models to predict the likelihood of fraud and flag claims that need higher scrutiny. And the tools for predictive fraud modeling that State Farm uses, so that's quite interesting because they're provided by Duck Creek Technologies, which is an analytics company, which in turn relies on third-party systems, and more specifically, the FRISS software, which is called FRISS. And so this is a software that assigns score to a claim real time, apparently. And this score is known in the industry as FRISS score. And it's based on both the internal data that the insurer holds, but also on external data. And that is from actually their website. They claim that they apply techniques such as AI text mining, for example, to detect questionable language patterns in the insurance claims submitted. So going back to this question that we asked at the beginning, so what's actually new? Well, these cases show the examples of that, of what's new in this context. We know that discrimination laws prohibit race discrimination, and I hope that financial firms do have systems in place to prevent that discrimination. But what is new with the use of AI and machine learning tools is that it's much more complicated to control for that discrimination, to control for bias, because the models are often opaque, they're supplied by third parties. And so even it may be the case that the firm that's using those models don't really know what's going on inside. And also, it's quite interesting because these algorithms, while they are facially neutral, they do perpetuate the existing inequalities, and they also create those feedback loops that amplify the historical inequalities quite often in unjustified ways. So that's the example of this, when I'm quoting, detecting of questionable word patterns. And this amplification is illustrated in that lawsuit. So the plaintiffs allege that biased anti-fraud algorithms become actually self-fulfilling, because if there is racial bias in the claims that are identified as potentially fraudulent, and then because of that they're investigated, so there will be racial bias in the claims which are found to be fraudulent, because you won't find fraud in claims that you don't investigate, right? And so where biased claims processing models subject black claimants to greater scrutiny, more fraud will be found among black claimants, and that will result in continuing and increasing scrutiny of black claimants. So this is this sort of the feedback loop. So Susan, would you like to comment on this idea of using the third-party software?
Yeah, so I think the issue is that we've got two technology systems that have been identified by Zofia. One of them is well known and used globally, and the other one is as well, but not so much, as the credit scoring system is fundamental to the way that credit is assessed. But when you look on these websites and you look at who are using these systems globally, including on one of them, a New South Wales state government agency here. So these technologies are already, according to their own website, in use in a lot of places. And the issue that it raises for organisations is, how do you assess that risk? And when it comes to the board, what information do they have? That's the first thing. The second thing is privacy and security by design. So what are the procurement steps and what are the risks assessments involved at the procurement stage in relation to mitigating known biases and harms when you're using a lot of personal data? So I think whilst these are US class actions, you can see with developments here that we're likely to head down the same path if these issues about the feedback loops and reinforcing biases in data is a problem. And, you know, we'll talk about some of the other cases where there are other sort of harms that arise out of technology use.
Yeah, so another example that we thought of is the hype that actually surrounding, especially those new things such as, you know, ChatGPT and large language models, or LLMs. So I think this is in itself, it presents risks to boards of companies, and that includes obviously financial firms that are interested in using those technologies, because the hype itself can result in harms. So as an illustration, quite recently, McKinsey published a piece that's entitled "What Every CEO Should Know About Generative AI." And it provides some advice, which is not, I would say, confirmed by rigorous scientific evaluation. So, for example, it's claiming that you can use generative AI in fraud detection. So you would put your customer documents in that tool, and you would ask it to identify fraudulent transactions. But this idea just rides the hype. Then there are other tools that are much better suited to fraud detection tasks. And it's not like the generative AI will magically know the answer to a question if certain transactions are fraudulent. So thinking back to those harms that we identified at the beginning, this would be a clear example of an maybe inappropriate use of AI tools. And this sort of hype and misleading advice is quite common. So just last month, we received a newsletter from the Australian Institute of Company Directors on how generative AI can expose companies to risk. And there is quite a lot of good information in that article, but then it's even more surprising that they say certain things, and I will quote that one. So they say, generative AI is extremely good at ingesting lengthy and complex documents such as legislation, legal contracts, or financial reports. A human can then interview the AI tool about what it has learned and ask it to summarize the document. So for example, you could ask ChatGPT to summarize an economic report from the Reserve Bank by emphasizing how it will impact medical centers in South Australia. This review and summary process works not only with text-based documents in multiple languages, it also works with computer code, Excel formulas, and other frameworks. And again, this is not quite true. So the longer and more complex the document is, the more likely it is that the AI tool will make mistakes. For example, it will summarize the text selectively. And also, while it does work reasonably well in English, this is just not, I don't think it's true that it's able to work in multiple languages. So I'm Polish, and ChatGPT's Polish. It speaks very poor Polish. So, and I don't think it will actually ever learn, because there are not that many documents online available in Polish. So, and the problem that we're seeing is that this narrative is being promoted. The whole hype is that LLMs will solve every problem. Why in reality, many of those problems have already better, simpler solutions, which are task-specific. And so you could think about, I don't know, spam filters in an email, so in your Gmail, for example. And and the main issue with this narrative for company decision makers, for the boards, is that they may opt to use LLMs where it's not necessary, and where those models are less effective, more expensive, and overall more risky because they're opaque, because they are external to the organization, and that means that they can expose internal data through third-party APIs. So I think the firms should really start thinking about embedding AI in their day-to-day operations.
Well, just one of the things on generative AI is that large language models use huge amounts of energy to actually run the queries. So if you're an organisation that's going to be reporting on ESG or concerned about environmental issues, it uses enormous amounts of energy. So, for example, in Ireland, where the headquarters of Facebook, Google and Microsoft and some of the big tech platforms are in Ireland, the storage, the data energy cost is 17% of the total spend in Ireland, which is the same as all of the domestic households. Globally, it's about 2 to 3%. So that's what cloud storage, data storage is using in terms of energy. So you can see in Ireland's case, where you've got these big tech platforms storing all of this data, what the drain is. So if you do a keyword search to find something on the internet, you come up with a lot of searches. But if you start using large language models like generative AI, it sucks up an enormous amount of data. So that's just one issue. But we'll come to the issue around, Sophia's said about all of the risks to external risks, but there's also other cyber risks as well in relation to the information. So as with everything, the quality of the data that you have will dictate the output, and you need to have proper governance controls over the system, but also all aspects of the system. So just not the system, but the data, the users and the outputs of it as well, and it needs to be continually monitored and looked at.
Yes, so, and thinking about those pressures, we're thinking that, another internal pressure that the boards have to deal with is shareholders. So that's an example here that we have is from the activist shareholders at the Travelers Insurance Company in the US that proposed a resolution to conduct an external audit of the racial bias and discrimination. And that's both in relation to the clients, so the insureds, but also to their own employees. And that's quite interesting, and I wanted to draw your attention to the board's response to this proposal, where they claim that conducting such an audit would actually be against the law, and notably because the company does not collect or utilize the racial data on their insureds, and they would have to use such data to be able to conduct the audit, which is not entirely true, again, because you can measure bias of your decision-making tools, for example, using synthetic data. So although there is definitely some balancing involved in terms of complying with privacy and data protection on the one hand, and then preventing bias and discrimination on the other, especially in the context of those AI tools. So far, we have discussed a number of examples of risks that AI tools may bring for companies, and especially financial firms. What do you think, Susan, that the organizations are most concerned about?
So I think when we've traditionally talked about data in recent years, it's been cybersecurity and reputational rather than regulatory compliance here in Australia. That's just my personal view. I'm not sure that organisations fully understand the commercial risks of operating and maintaining these systems and what's involved, and also when you implement new systems, new AI systems. So we've talked about the digital transformation, the driver to implement AI reduces costs and creates efficiencies in all organisations, even in government agencies, but it's got to be done properly. And this notion of costs, ongoing maintenance costs, failures around performance needs to be taken into account. The reputational thing, I think everyone is acutely aware of, and breach of legal obligations. So that requires regulators to actually enforce the laws that we already have. And sometimes we see that, and sometimes perhaps there's a lot of public outcry before we see regulatory responses. And now we can see in relation to the major data breaches that we've had multiple class actions against organisations. So we can see developments now here in Australia as well.
So just for the sake of completeness, like we discussed those Wells Fargo and State Farm lawsuits. And obviously, since these are lawsuits, it shows that there is perfectly a framework of rules that apply to financial firms that are very relevant in the context of the use of AI systems. And just some examples. So just an overview, really, of particularly relevant rules. So if we have an AI system that misuses data or personal information, obviously that might breach privacy laws, data security obligations, confidentiality obligations, risk management obligations, IP laws, and so on. If the system produces an incorrect output that could include misleading advice or provides unfair or unreasonably harsh treatment, for example, then this is conduct that could potentially be covered by obligations, so conduct obligations of financial entities. So, for example, the obligation to provide financial services efficiently, honestly, and fairly, prohibitions of misleading and deceptive conduct, unconscionable conduct, unfair contract terms. So clearly also all the rules that protect financial consumers, financial product governance rules, so product design and distribution obligations that prevent mis-selling of financial products, and so on. And obviously, anti-discrimination laws apply as well. Which brings us to consider key obligations in the design, development, and use of AI systems, which Susan already started hinting at, where we've got the legal and regulatory environment and the rules that will apply to financial firms and the use of those AI tools, and how they translate into the internal processes in a company that are designed to ensure that, that company directors comply with their duties. So over to you.
So as this first, can you just go back to that slide?
Yep.
So we've touched on that there can be breaches of privacy laws, consumer protection, cybersecurity, anti-discrimination, failures in relation to duty of care, negligence, and breaches of work health and safety regulations. So there's a lot of existing laws, is the point, where AI systems may not be compliant with the current requirements. And then on top of that, we've got the requirements of organisations and directors and officers. So I wanted to start, because we're in the financial sector, with the Prudential Standard CPS 230. This is the APRA standard that applies to APRA-regulated entities. And they're required to manage all of their operational risks, legal, regulatory, compliance, technology, data, and change management. They're also required to maintain appropriate and sound information technology to meet current and projected business and to support critical operations. And they also must comply with the requirements of Information Security Standard 234. There are also other standards, so that's the operational risk management standard. I've mentioned the information security, but there's another one, outsourcing. And between those three regulations, there are a lot of requirements around registers for information assets and management and keeping track of and recording third-party providers, which includes providers of systems. So really understanding your systems. So the first case I just wanted to touch on was an interesting one last year that ASIC brought against RA Advice. It's actually a cybersecurity case where there'd been a number of data breaches by a subsidiary initially of ANZ Bank, which was later sold. So there, we think of disclosure of personal information being a breach under the Privacy Act, but here it was found that there were inadequate systems and the inadequate risk management systems, and as a result, there was a breach of Section 912. So here, there was a breach of both subsection A and H. A includes the making sure that things are done efficiently, honestly and fairly, and the word fairly comes into play here. It's subject to subsection 5, the issue of adequate risk management systems, and there's an exclusion there for APRA-regulated entities, which is why I wanted to start with the requirements of risk frameworks and information security requirements under the APRA prudential standards that's required of organisations. So under the Corporations Act, we've got the duty of care and diligence in Section 180 and the duty to act in good faith under Section 181. So Section 181 is directors must exercise their powers in good faith and in the best interest of the corporation and for a proper purpose. So here we're talking about, for AI systems, directors should be or must ensure that they are properly informed about AI systems that they're installing and rationally believe their decisions in the best interests of the company, having properly considered the potential impact of these decisions. Now, the more likely outcome, we can talk about this in the discussion section, is the use of due care and diligence, Section 180, which is directors and officers must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would exercise. If they were in the same corporation, etc. Now, there is some case law on what's expected, but Justice Beach in Mariner included that it's the terms and conditions on which the director is undertaken to act as a director, how the responsibility for the company's business has been distributed, the informational flows and systems in place, and the reporting systems and requirements within the company. But it is quite clear, for example, under the APRA requirements and also Principle 7 of the corporate governance principles, which apply to ASX-listed companies, that it's expected that that organisations, financial institutions, will have fit-for-purpose risk management frameworks that deal with all of the risks, which quite clearly include technology and data. So, and we can talk more about some of the issues that arise in dealing with the sections and some of the problems like what defences may or may not be available.
Yeah, so just one additional point, which is about there is still a bit of a question, so there are some open questions in how we can apply existing rules to AI tools. And an example here that I brought up is about relevant rules, so laws that actually expressly mention a person. So in this case, so first, that's in the first example is about anti-discrimination laws. So that's the Sex Discrimination Act 1984. And Section 5, subsection 1 says that for the purposes of this act, a person discriminates against another person on the ground of the sex of the aggrieved person if, by reason of the sex of the aggrieved person, they treat that person less favorably. And so there is some discussion in the legal academic literature on AI as to whether this state of mind, so for example here, a knowledge regarding the discrimination, or so if it's actually included in this causation test, so by reason of, and how this might exclude a decision that's made by an AI system from the application of that section. And similarly, we have a defense of Section 189 of the Corporations Act. So this is when a director can reasonably rely on information provided by others. And it's obviously formulated in a way that includes only humans giving advice. So again, it's potentially an open question if such advice could be provided by a machine. Now, I think, so my personal opinion, it's always a person making a decision. So even if it's an AI model that comes up with an output, there is always a person, natural or legal, that should be accountable for that output and whatever harms derive from it. So going back to the question that we sort of started with, that Susan started discussing, so the risk management frameworks. So where are we at, Susan?
So it's interesting because this survey here, which came out at the end of last year, which is in machine learning in banking. So as we've already said, you know, there's a lot of AI already in use in the financial sector particularly. What's really interesting to me about this survey is that it says 80% of people have data governance within their organisations, but if you go halfway down, enterprise-wide risk management, it says only about half there. Now, that just can't be right. It would be, you know, most of these organisations, if not all, would have a risk management framework in place. So this goes to who's filled out this survey and who understands the risk management framework. But it also raises in my mind how well integrated or not these issues are. So data governance is usually, in my experience, over certain sections of data within an organisation to leverage the data to extract value. Most organisations have a very serious challenge in managing the massive, exponentially increasing volumes of data. And as we've seen in recent data breaches here, they've not been disposing of it, which is required under the current privacy regulations when it's no longer required. So if it's no longer required because you don't have permission to use it or it's outside a retention period, then you should be disposing of it. So there's a disconnect here. Also, outsourcing and third-party risk management is at 45%, which I think is surprisingly high because in my experience, this is a real challenge. And when you look at some of the massive data breaches that we've been having, including the file transfer one earlier this year, which affected, I was just looking at a US government advisory report on that, 3,000 organisations in the US, including US government agencies, and 8,000 globally, and under a different name here in Australia to the one in the US. It was reported that, for example, the Tasmanian state government had been caught up in that. So that's just, these are the issues about using third-party systems, and often, like LinkedIn had a big data breach this year, but it wasn't LinkedIn. It was it was LinkedIn, but it was caused by one of their third-party suppliers, and I think that was 700 million users. So if you can't have these big tech companies able to manage their own third party, then you know raises questions about organisations here and the challenge and the difficulty that you have. So it's not only when we come to technology cases, I want to take a broader look because non-compliance with anti-money laundering laws has led to the largest corporate fines in Australian history, 1.3 billion against Westpac and 700 million against CBA. Now, the CBA case arose out of...
50 million against Crown.
Sorry, Judge. I've just been reminded that first and third, His Honour's recently approved a settlement. Is that the word I used?
Fined Crown 750 million.
Fined Crown $750 million. I apologise. So first and third. An ATM was put in. It wasn't configured to record transactions of more than $10,000. So that led to, I think it was reported, bikie gangs and sort of criminal syndicates stuffing ATMs full of money and transferring it. The Westpac case went back to technology issues that went back to 2011. They'd been on notice of the CBA case for a couple of years or thereabouts before they also found themselves responding to an AUSTRAC action as well. The Westpac case is interesting because they had spent something like $500 million, it's reported in the judgment, on compliance. And this is the thing that really worries me about the use of AI, because large organisations spend a lot of money on compliance, on systems, on privacy impact assessments, cybersecurity assessments. In Westpac's case, they'd spent a lot of money on consultants. Some of those consultants had identified weaknesses in the systems they had. The board, according to the independent review, received reports going up to the board flagging issues. So often in board reports, you rate your risks and they're reported accordingly. So you get green, which is good, orange, where there's a risk, and red, where there's a real problem. And there were certainly flags that went up to the board. So the issue is, in those cases, these were AUSTRAC actions. There was no other action against the organisation. But what is the harm? You've got money laundering going on, and in the Westpac case, the judgment refers to known pedophiles who were transferring the money. So when we talk about Section 180 and foreseeable harm, Justice Edelman in ASIC and Casamata said that it's not only concerned to financial harm when we look at the interests of the corporation. Harm includes all the interests of the corporation, and it includes its reputation, including interests which relate to compliance with the law. And I think that's really important in this discussion, because I think boards think, you've got a compliance arm and you've got a legal office and their job is compliance. But it's very hard with this new technology. You've got to make sure that you properly understand the risks. And also, what we've learnt from Robodebt is when red flags are called, you've got to take action. I mean, there are going to be lots of risks and mistakes, but a really important part is actually taking steps to mitigate them as soon as you become aware of them. So how can organisations achieve this? So as I've said, we've got a lot of silos across the organisation. Legal is generally separate to cybersecurity and IT, but it's also separate to, for example, information lifecycle management. Oh, right, sorry, thank you. So this diagram just recognises that there are lots of component parts, like data analytics and AI may be used for business intelligence, can be used fraud of employees, for example. That raises issues about whether the surveillance of employees complies with privacy laws and you've been given notice in accordance with relevant work surveillance laws, like the state laws we have in New South Wales. So I don't want to spend too much time on that. So one of the key issues is, as a result of these siloed areas, we've got IT policies, acceptable use of IT, we've got privacy policies over here, we've got record-keeping policies, we've got legal hold to stop destruction of documents, then lifting of the hold needs to continue. We've got innovation units within large organisations. So now you've got to roll out an AI policy, apparently. So you really need to, lots of these, most large organisations have so many policies, processes and standards you would not believe it. So what you need to do is to align all the relevant policies. It needs to be aligned under an information governance framework, and there are mechanisms for how you manage this within your organisation and what you need to do to make sure that this happens. And it needs to be aligned and fit into your risk management framework. And that may require your risk management framework to be adjusted, because your current technology reporting and your current legal reporting and your current auditing and your current compliance reporting may not be giving the directors the all of the information that they need to be properly appraised of the risks and to make an assessment in the best interest of the company. But I say that boards are responsible for ensuring they've got fit-for-purpose risk management frameworks and that they're able to properly assess the technology, including AI, data, and make sure that they can bring their people with them on that journey, because ultimately it's the people that implement the technology within the organisation, it's the people that use it. So just simple things. Somebody has to be responsible for the system and somebody has to own the data. And those sorts of accountability mechanisms are really important. And it's surprising when you sit down and you have tough conversations about well, if you want this new system, you own the data. It's like, oh no, I don't own the data. I just want to use it to develop a new product. And it's like, well, you know, if you're extracting it from this other part of the organisation and you're going to train it and use it in here, then somebody has to own the data. And that's where it becomes really interesting. So just to finish off, for projects involving AI, you obviously need to comply with all regulations, but particularly privacy compliance, privacy and cybersecurity by design. But that requires there to be an awareness about privacy, and I call it an information culture, that when you talk about cybersecurity, when you talk about AI to improve products for people or workers or whatever you're trying to do, the business, it is about protecting the data and information that you have, both so it complies with regulatory compliance, all of your regulatory compliance, but also so it is protected, particularly in that cybersecurity sense. So cybersecurity is simply that you keep the information secure, not only from hackers externally, but from the insider threat, which is also a big issue, and also to prevent the biases and all the other things we've been talking about today. So we talk about, in every AI standard and even the regulations that are now being developed, transparency, accountability, reliability, all of these words. But transparency and accountability are the two key ones, and they are the two key anchors for good governance as well. So in relation to boards, are they receiving fit for purpose reporting on AI systems that are already in place and new developments, reporting on data and information as a whole, and the full gamut of regulatory compliance in relation to privacy and personal data. So I think that finishes us off, Jason.
Hand over to.
Well, it was about 200 metres from this room, and unfortunately about 38 years ago, that I first heard of a Danish philosopher and theologian called Søren Kierkegaard. And one of his most profound quotes was, "Life is lived forward but understood backwards." And it's very true of understanding the law and massive developments in the law. Because the whole idea that we can sit here now and speculate about what are likely to be quite profound changes is one which would make the gods laugh. I have no doubt that AI risks are going to be an extraordinarily important topic about the development, particularly in relation to litigation and regulatory proceedings specifically. Let me start by saying something at not only a high level of generality, but perhaps a stratospheric level of generality. Dealings between individuals create individual rights and individual obligations. When things go wrong, there are individual complaints, claims, causes of action and potential for litigation. The extraordinary change which is developed through the sophistication of machine learning and AI is the movement away in so many areas from individual decision making in relation to individual data and what might be described as collective analysis and collective decision making by reference to collective data. Now, one sees this in the whole range, the whole potential gamut of commercial relationships. But once you start dealing with data and once you start dealing with people on a collective basis, you're bringing into play the real possibility that you give rise to collective claims. What does collective claims lead to? Collective claims leads to 7 or more persons potentially having a claim against another person. What does that lead to? It leads to the engagement of Section 33C of the Federal Court of Australia Act and cognate provisions in other Supreme Court acts and the like, which give rise to the ability of a representative applicant to bring a class action. Now, I probably have been involved in more class actions than anyone in this country, both as a barrister and as a judge. One thing I can tell you, and this should come as no secret to anyone in this room, including particularly the person on my left, is that class action lawyers may have their limitations, but one of the things they're good at is spotting vulnerabilities and opportunities in their headlong rush to make money. And the prospect of litigation is enormous. I mean, Susan just spoke of 2 cases. Now, I mentioned Crown not entirely facetiously, and I won't say anything about it because the case against the directors was before me in court at 9:30 this morning, and I've still got to deal with it. I've dealt with the asset claim against Crown because of systemic failures, risk management failures, where AUSTRAC brought proceedings against Crown which led to certain admissions being made and a $750 million penalty. The outcrop of that, of course, is the class action against the directors, calling in aid the very sorts of provisions that Susan was speaking about. I obviously will say nothing more about that case, which will be heard It was going to be heard in February. For a variety of reasons, I've had to defer it, so it probably won't be heard until the latter part of next year. But it does raise a number of very important issues. In a way, one of the reasons why I say we haven't really quite understood the nature of the changes and the developments that might arise is because of, I think there's a certain naivety sometimes as we approach these problems. I was part of and I was just thinking of this on the way, part of a full court in Australian Securities Investment Commission and Westpac Banking Corporation, which for people, any lawyers in the room who should use the authorised reports, is reported volume 277 of the Federal Court Reports at page 343, and ASIC decided, and I, together with Justice Gleeson, I was in the majority and Justice Middleton dissented, but ASIC was sensible enough not to seek special leave, so it actually does accurately reflect the law. But that was a case where I can tell you from 2011 to 2015, Westpac entered into more than 250,000 Westpac branded home loans with its customers. And those home loans were approved by Westpac's ADS, or automated decision system, without being referred to manual assessment. As part of that application process, Westpac collected information from consumers, including details of their expenses. And then Westpac, through the use of this automatic decision system, applied a number of rules, including various ratio rules, which were applied to assess the risk of default without then going to the more granular serviceability information and living expenses of individuals. You may recall this was the Wagyu beef case at first instance, but this is the appeal. The use of benchmarks and the use of this automated system, I can tell you, was undertaken by Westpac in 2011 without really the consideration of these issues which have become brought into greater focus as we've started to think more deeply about AI. It was effectively just seen as a mechanism by which assessments could happen more efficiently. Now, in the wake of the Banking Royal Commission, ASIC then brought proceedings saying, well, the failure to look at this individual financial information meant that the bank was failing to comply with what might be described generically as the meet your customer obligations in the ASIC Act. I described that as a legislative porridge that I really couldn't understand. It was completely incomprehensible, and that's why I thought Westpac shouldn't be slotted by ASIC. Justice Middleton was harsher on Westpac than I was. But clearly, within an organisation such as Westpac, the notion of deploying this automated decision-making system would be thought of, I think, and the risk assessed entirely differently today for the reasons that have been explained, with an increased consciousness of the interplay between machine learning, AI, and automated systems generally, and regulatory obligations and the potential for litigation risk. One of the interesting things about that case is I remember I was sitting in my chambers and my bank manager came up dealing with something, and he knew about the case, and he said to me, oh, you were in that case. We're very glad to see that case went that way. He pointed out the window of my chambers and said, look over there, which is the eastern suburbs of Sydney. The day after that case, those property prices went up 10%. And I think, well, I'm glad you didn't tell me that before I started the case, and I have to disqualify myself because I had no idea it would be, because it stopped the logjam in the assessment of cases. But there are a large number of cases in the court at the moment where you can see the sort of regulatory risks that have been discussed so compellingly tonight are starting to manifest themselves in large-scale litigation. There's a couple of cases of which very recently, well, perhaps not as some more recently than others, but the Travelgo case, where you recall that there was an algorithm where 60% of its time it would nominate at a hotel offer more expensive than the best offer, contrary to representations that were made concerning how the website was to work. That's the sort of thing which is obviously likely not only apt to lead to regulatory litigation, but also class action litigation. There's the ASIC case against Insurance Australia Limited, where IAG used an algorithm to minimise premium rises and falls when insurance policies were renewed, and it allegedly failed to pass on no-claim and loyalty bonuses to customers. Again, regulatory proceedings, which, if they haven't already started, I presume they've already started, but if not, are very likely to lead to class action litigation. So boards have to be highly cognizant of the fact that really there are two areas of discourse which may not be speaking to each other very well. One is a regulatory side of the business, one is the litigation, the people who assess litigation risk and think about the consequences. And the boffins, the IT people, who are constantly devising and assisting, and the machine capability of learning itself, which do not place at the forefront of developments this notion of litigation risk and regulatory risk. And that, in a sense, is the tension that has been talked about tonight. It's one that I think is going to involve a great deal of litigation, and for those lawyers here who are involved in litigation, that's probably a happy thought. For the persons who are the respondents or the defendants in this litigation, it's obviously an appalling spectre. For me, it just means more work. And having taken the King shilling, it doesn't to give me any financial benefit. But I hope, like me, the comments that have been made by our speakers have stimulated some thought, particularly about the acute nature of the risks that AI raises. And thank you for the opportunity of saying a few words before you go back and watch the soccer.
So, ladies and gentlemen, we have some time for questions. Do you have any questions for our speakers?
This is from an accountant, Graham Dean from the University of Sydney. My issue relates to the structural arrangements within which these risks occur. And I'm wondering whether there is any problems greater than have been discussed when we consider the corporate group structure that is the common structure that's used around the world, where subsidiaries are used consistently, either wholly owned or not wholly owned, related parties, whether the artificial intelligence risks may be, if you like, somehow bypassed into some of these operating subsidiary companies to make it even more difficult to assess the risks to the community as opposed to the risks to the companies. I wonder if people would have any comments on that.
So I'm laughing because actually I think it was yesterday or 2 days ago that I met Professor Jason Harris here in the corridor. We both work here in the law school, and we were just thinking about this this very question: how those risks. I mean, it's a very complex problem, right? So. First, from the perspective of the organization. So the idea is that in a corporate group, obviously, each of the companies will have a separate legal personality and their own liabilities. So then it's very interesting how those risks might be translated, and how they might spread between those different companies in the group. And I think there is a very, so the risks for the companies are actually very closely linked to the risks to the society, in terms that, what we were talking about today, that it's the risks to the society, so the harms that happen to the society that translate into class actions or in lawsuits in general, and into reputational, regulatory and commercial risks to the companies.
I mean, at the end of the day, I don't think the structure with which a corporate group is organised is going to make, over the long term, much difference when it comes to getting people on the hook at the end of the day. Because the obligations of whoever is controlling the company is to manage risk wherever that risk arises within the corporate group. And the obligations will be informed, and the content of the duties will be informed by the amount that that board or the holding company knows about what's going on. So whatever way it operates, there may be an ability in some cases to be tricky and isolate certain risks, but I think the ingenuity of lawyers of thinking ways around that to allocate risk properly is not to be underestimated.
And I'd also add to this discussion about you probably referring to the situation where somebody's developing AI rather than buying a system and just using it, because a lot of these systems don't cost a lot, annual subscription fees or whatever to set up, and they're being implemented, and it's around the safeguards that you put in place not to cause harm, basically, within the organisation, that are not often understood. Because practically what happens is there are KPIs within the organisation to develop new products or save money, and technology companies, people are looking around for solutions, technology companies are selling solutions, and then you have somebody who's actually the business user, responsible for saving costs of developing a new product, or HR or whatever, saying, we need to use this new system, it's really fantastic, it will save us a lot of time, or whatever. And that's how it comes usually to the organisation. It may then go through a procurement process. It very late in the day comes to legal, and that's an issue. Very late in the day it used to, well, not even go to privacy, but now organisations know they've got to do privacy impact assessments and cyber risk impact assessments. So I think there's two different issues.
I was just going to add, we have principles of Pearson and Corporate Vale in Australia, although if you were to set up an AI system in a subsidiary, which is, it seemed, what you were referring to, the undercapitalisation ground, for example, hasn't been recognised in Australian law anyway as providing a sufficient ground to pierce the corporate veil. We might be able to use that type of arrangement perhaps to try and establish an agency between one or more holding entities and a subsidiary that's then providing some sort of essential service for those other entities. But to build on the judge's comments, and actually I would go back to the session that I gave on this in this particular series of talks back in June. I think principles of accessorial liability might be available there as well. Okay, any other questions? Question up the back.
Thank you. From a companies and directors perspective, when you're dealing with particular terms and conditions where it can be less than clear, how do we think the actual consequences may be for the companies involved? Because, as you mentioned, a lot of these tasks may be outsourced and they may have the data going to external parties here or overseas, where the data is potentially stored, used to build alternative models, used to build things that may be against the consumer's interest, and the companies have been responsible for that. It may be very much hidden in terms of conditions. Is this something where the Unfair Contracts Act could step up? Or is this just another challenge that the privacy considerations need to look at?
Okay, I couldn't catch all of that, but in relation to, issues about, for example, data storage overseas, you should be, and these organisations would be doing privacy impact and cyber assessments. And for example, if you're a government agency, you're supposed to be storing it obviously here in Australia, but you know, in the past I've had discussions with people saying, oh yeah, but everyone else is storing it in X, Y and Z. And so there is this hangover issue, but I think most organisations now understand that it should be stored here. But one of the issues that I think is arising is the ongoing monitoring of systems and how they change, and making sure there's adequate systems in place. But the thing is, if you want to do business with one of the big technology providers, there's very little, if any, room for negotiation on standard terms, which is what the point that you're getting at. You know, I have been known for saying in the past that, you know, if you're serious about developing your IT capabilities, then if you're a large organisation, particularly a government one, you should be building them internally, not necessarily outsourcing everything.
And just an additional thought, in the context of generative AI and LLMs, that's a big problem, because those, as Susan mentioned, they consume enormous amounts of energy, but also they require extreme amounts of computing power. And that's a big problem if you want to develop those internally. You probably cannot. You have to rely often on external services in that case. So that's obviously a big risk.
I mean, we're probably getting a little bit off track, but if you've been using any of these, trying these systems out, I'm amazed at what they can't do, and you might have something to say here, Matthew, but you know, it's there are some reports that, for example, for a legal case, if you put data in, and Matthew will know the article I'm referring to, so if you put in all the data from discovery relevant to a particular witness, for example, and ask it to review the data and draft a statement, it will be able to do that very quickly and do a pretty good job. Matthew, would you just like to say in a loud voice what that article says? Because I didn't really read it, but I did notice it. But, you know, this could actually reduce, it has ramifications, particularly, this is what generative AI is how it's going to change, particularly the accounting and the legal profession, because there are things it will be able to do. But the thing is, when you're just putting a general search query in on a case or looking for things, it does, in my experience, hallucinate quite quickly. Matthew, would you like to contribute at all, or am I putting you on the spot?
That's a very frightening prospect, that you can have an AI-generated statement by reference to documents produced on discovery. It reinforces the view that I often say, and that is affidavits or statements prepared in that way remind me of the great quote of Lord Buckmaster, which was that the truth comes out of affidavits like water from a leaky well. And the only way you're really getting the truth is by getting people in the witness box and then giving evidence orally about their true recollection. And there's a number of judges, I'm one of them, who have gone back to that old-fashioned method because we're sick of seeing evidence produced by the solicitors rather than by the witness.
Well, and what would happen is that it just means that all of that initial stage that used to be done by the lawyer and the initial drafts would be automatically done, and then it would go to the senior associate or whatever, and then the partner, so it would cost a lot less. But you're absolutely right, and His Honour, we did some cases together, and of course the Justice Lindsay Foster, I did a Royal Commission where I was the internal solicitor assisting, and I remember one weekend him berating me about the electronic document system not working, and myself and one of my junior solicitors would have to go through all these boxes over a weekend to find the evidence. And it was the second Royal Commission into the same issue, and 10 years later we did find more documents for various reasons. But there are certain people that you work with that, you know, say, as I learnt very early on, where was the second diary? So you're not actually going to pull everything up necessarily through technology reviews, but it certainly saves a lot of time. Matthew.
So I'm not sure what you want me to talk about, but the article was, it was showing off, but basically proving that, so I'll go off on a tangent if you want, but so that there are two primary generative AI systems that are winning at the moment, the OpenAI models, so ChatGPT, GPT-4 and so on.
Might need to speak up a little bit more, Matthew,
Okay,
so
so-
that people at the back can hear you.
Yep,
Maybe
so-
stand up, yeah. Do you want to? Yeah, it'll be easier.
Okay, so I'll now talk about LLMs and GPT. So the thing you were talking about was an article on proving that you could feed an AI system a set of documents and you could prove or disprove questions about the documents. So you could effectively, as Justice Lee was saying, produce an affidavit. And I'm a technologist at Gilbert & Tobin. I'm talking personally, not on behalf of GNT, but to me an affidavit is a chronological story that is setting out a series of facts in chronological order, and each paragraph is a summary. And these generative AI systems are pretty good at summarizing text. And so what the article was talking about was it got the system to summarize documents and then fed summaries in, and then it synthesized a research memo from a senior associate saying, here is the research that you asked me for, and it can do all of this in seconds or minutes, basically.
So that's how some of the industries will be transformed, but it still doesn't address the problem that Zofia talked about earlier, about all of the problems with training data sets, and I think the curse of the recursive, as I was listening or reading about something the other day about you train the data and then you feed the trained data back into the system, and that's the sort of thing that Zofia was talking about, like reinforcing biases and leading to greater harms in that sense.
Just as I'm listening to this discussion, I think back to what Justice Middleton said in the ASIC and Healy case back in 2011, where he was talking about the important role that directors have in particularly public companies. And as some in the room would know, in that case known as the Centro case, one of the central issues was an overload of information, that the directors were receiving board packs of thousands of pages, complex information, often very short time periods before board meetings. And the failure of those directors to actually read the information, because they had developed a board practice where they would rely on senior executives like the Chief Financial Officer to effectively warn them about, well, here are the really important bits that you need to read. And of course the criticism of that. But then on the other hand, to talk about the Royal Commission, which I think was mentioned earlier, and what Commissioner Hayne was warning about, that it's not a case of just saying directors need more information, because we're living in a world where we're producing just unfathomable quantities of data. So it's not about more information, it's about better information.
And that's a good case, and I had the experience of cross-examining those directors in the class action, which immediately followed ASIC and Healy. And you're quite right. There was a huge amount of information that went to them, but the business itself was so opaque and complex, although I might say what they missed was not obvious. It was pretty bloody obvious. And that's why they ended up paying $250 or $300 million for their shortcomings. But it is a problem. The real vice is the increasing complexity of the way of business organisation, particularly one as complex as Centro, and the complexity of the information that's given to people.
So after the Royal Commission, ASIC did a investigation and report into the issue of information flows to the board, and what they said on this issue of, you know, voluminous board packs, that directors had too much information, and it's information overload. The issue is getting the right information to the board. And when I look at board reports going up, I don't think directors are necessarily being appraised of all of the risks in the right way that I see it around information and the use of technology, because it's siloed. Like major projects, we've got a major technology system, major project reports on that, legal reports on new privacy regulation or some other new regulation that's coming in and how that's going, compliance reports on compliance, auditing reports from an auditing perspective. So there needs to be this more integrated reporting on data, technology and regulatory compliance.
So
I've got to tell one story though about that case.
Much more
Even though there was
interesting.
complex material, one of the key critics, they missed a current liability in these board packs. And the current liability, I remember saying this fellow, he's saying, "Oh, I just couldn't see it. It was too." I said, "It's greater than the GDP of Chad." You got to laugh. They got it.
I like that the CEO in that case said in the ASIC litigation that, you know, he didn't want to focus on that. He wanted to focus on more important things. You know. But Susan, just coming back to your point, I mean, I know there is no one answer here, and I think a lot of what we're talking about here are larger organisations that have resources and have a lot of professional advisors. But with this problem that you're identifying, is part of the answer that we need to really have data governance officers at senior levels inside companies?
Well, a lot of financial institutions do, but you've got to ask them, what are they doing? And usually it's trying to get the data in order to leverage the data value. Right. And my view is that data governance is just one aspect. It's like the fundamental part of it, like it's a fundamental building block, as all of these policy alignment is as well. But it's all of the risks. It's, you know, to Matthew's, Matthew was involved in the Royal Commissions and in document production from the banks. It's well known that CBA, which Matthew didn't have anything to do with, I don't think, but they had more than 500 notices to produce. The notices went back 10 years. In large commercial litigation, often I think a third, 40% of the total costs of the litigation, so we can be talking about costs of tens of millions of dollars, is document production. I mean, it's crazy. And if you're keeping all of the data and not disposing of it, it's of enormous cost. And if that's not bad enough, well, then the big recent data breaches of Latitude, Medibank and Optus have highlighted that. And I know at least one person in this room that's had their data taken in all three breaches. And there are horror stories now about what's happening to people whose data has been accessed from those three organisations. So it's not surprising that in addition to the regulatory investigations, we've got class actions there as well.
Okay, I'm just mindful of the time. I think we might draw it to a close there. We do have some refreshments, so I'm sure we can continue the discussion there, but if you can join me in thanking our panel tonight.